Similarly, there is another requirement to be followed under the takeover code, that is what is the offer size. We have to be aware of this particular fact that all these provisions are given under the takeover code to make sure that a takeover or acquisition, even if done in a hostile manner or friendly manner, is not against the interest of the minority shareholders or investors or target company. Therefore, what should be the offer size in a takeover is provided under Regulation 7. Regulation 7 explains that any acquirer who has already made substantial acquisition of shares or voting rights or control can make an offer for at least 26% of the total shares of the target company within a period of 10th working day from the closure of the tendering period. Now, what does that mean? It means Regulation 7 allows to make an offer size of 26%, and the acquirer has already made a substantial acquisition of 25% as allowed by Regulation 3. Therefore, under the new Takeover Code 2011, an acquirer company in one go can acquire 25 plus 26%, that is up to 51% of shareholding or voting power or control in the target company, which gives a very broad scope to the acquirer company to acquire shares in the target company. The voluntary open offer made through public announcement under Regulation 6, it enables the acquirer to acquire at least such number of shares as would entitle him to exercise an additional 10% of the total shares of the target company. But the post-acquisition holding of the acquirer should not exceed the maximum permissible non-public shareholding applicable to such target company. The limitation in terms of offer size is not same in case of a competing offer. If the offer is a competing offer and the acquirer has made a voluntary offer, then he is entitled to increase the number of shares within a period of 15 working days to such number as he deems fit. And after the lapse of these 15 days, the acquirer shall not be able to increase the offer size. Regulation 8 provides us and states as to what should be the offer price and how it should be calculated, which again has been stated or mentioned in the interest of the shareholders of the target company. In case of a direct or indirect acquisition of shares or voting rights or control over the target company, the offer price shall be the highest of the following. It shall be the highest negotiated price per share of the target company for any acquisition under the agreement attaching the obligation to make a public announcement of an open offer, or the volume weighted average price paid or payable for acquisitions, whether by the acquirer or by any person acting in concert with him during the 52-week immediately preceding the date of public announcement, or the highest price paid or payable for any acquisition, whether by way of acquirer or by any person acting in concert with him during 26 weeks immediately preceding the date of the public announcement, the volume weighted average market price of such shares for a period of 60 trading days immediately preceding the date of public announcement as traded on the stock exchange, where the maximum volume of trading in the shares of the target company are recorded during such period, provided such shares are frequently traded. Where the shares are not frequently traded, the price determined by the acquirer and the manager to the open offer, taking into account valuation parameters and such other parameters as are customary for valuation of shares of such company, and the per share value computed under subregulation 5 if applicable. So therefore, whichever is the highest price out of these, that shall be the offer price under the Takeover Code 2011. Now, what shall be the mode of payment? This again is mentioned under the Takeover Code under Regulation 9. The mode of payment can be either in cash or by issue, exchange of transfer of listed shares in the equity share capital of the acquirer, or listed secured debt instruments issued by the acquirer, or issue, exchange or transfer of convertible debt securities, and the code also permits a combination of all these modes. Now, the code is not without exemptions. There are few categories which are exempted from the regulations, from the procedure mentioned under the code. These general exemptions are mentioned under Regulation 10. The first is acquisition pursuant to inter se transfer of shares amongst qualifying persons, being immediate relatives, persons named as promoters in the shareholding pattern filed by the target company in terms of listing agreement, or these regulations for not less than 3 years prior to the proposed acquisition. Another exemption is a company or its subsidiary, its holding company, other subsidiaries of such holding companies, persons holding not less than 50% of the equity shares of such company, or other companies in which such persons hold not less than 50% of the equity shares, and their subsidiaries subject to control over such qualifying persons being exclusively held by the same persons. The exemption also includes such persons who are acting in concert for not less than 3 years prior to the proposed acquisition and disclosed as such pursuant to filings under the listing agreement. It also applies to shareholders of a target company who have been persons acting in concert for a period of not less than 3 years prior to the proposed acquisition and are disclosed as such pursuant to the filings under the listing agreement, and any company in which the entire equity share capital is owned by such shareholders in the same proportion as their holdings in the target company without any differential entitlement to exercise voting rights in such company. Therefore, all these together form general exemptions under Regulation 10 of the Takeover Code 2011. Now, after having followed all these provisions with respect to making an open offer, making a public announcement, after having understood that how a voluntary offer is made, what is meant by direct and indirect acquisition, what should be the offer size and what should be the offer price, we should also understand that when this process of acquisition should be should be completed. Therefore, the provisions relating to and the procedure relating to the completion of acquisition is given under Regulation 22. Regulation 22 states that the acquisition process gets complete only after the expiry of the offer period. The Takeover Code mandates the opening of an escrow account into which the amount in cash equal to 100% of the consideration as fixed between the parties has to be deposited. That means that total 100% amount in cash has to be deposited into the escrow account. After the period of 21 working days from the date of detailed public statement, that is DPS, the code allows the parties to act upon the agreement and acquire shares or voting rights or control over the target company. The maximum period for the acquirer to complete the acquisition process is 26 weeks from the expiry of the offer period. This time period of 26 weeks may be extended by Board of Directors in case there is an extraordinary circumstance. And the Board of Directors, before granting such extension, would look into the interest of investors in general. The main issue which arises here is that if once the open offer is made or substantial acquisition offer is made, then whether an acquirer company can withdraw such an open offer. So, withdrawal of open offer is mentioned under Regulation 23 of the Code. There are only certain circumstances under which the open offer can be withdrawn, otherwise it is not allowed to withdraw this open offer. The circumstances are that if the statutory approvals required for the open offer or for effecting the acquisition, attracting the obligation to make an open offer under these regulations have been finally refused by the authorities, subject to such requirement for approval having been specifically disclosed in the detailed public statement and the letter of offer. Another circumstance can be that the acquirer, being a natural person, has died. Another situation to withdraw an open offer may arise wherein any condition stipulated in the agreement for acquisition attracting the obligation to make the open offer is not met for reasons outside the control of the acquirer, for such reasons which are outside the reasonable control of the acquirer, and such agreement is rescinded subject to such conditions having been specifically disclosed in the detailed public statement and the letter for offer. Or another ground can be such circumstances as, in the opinion of the board, merit withdrawal. So, in these cases, in these circumstances, an open offer once made can be withdrawn also. But if the open offer is withdrawn, then the acquirer within 2 working days is required to make an announcement in the same newspaper in which the public announcement of the open offer was published. The code mandates the information to be given in writing to the board, to all the stock exchanges on which the shares of the target company are listed, and the target company at its registered office. This is only to make sure that there is enough and there is proper communication done to the investors, to the shareholders, to the board of directors of the target company. Now, after having discussed and after knowing all these important provisions relating to takeover procedure, we should also understand as to what is the role of independent directors under the takeover code. The takeover code of 2011, it makes it mandatory for the board of directors of the target company to constitute a committee of independent directors. Now, these independent directors, they are also entitled to seek external professional advice on the same. So, once this committee of independent directors will be constituted, they have to provide written reasoned recommendation on such open offer which the target company is required to publish. Therefore, today we discussed the concept and the meaning of takeover and acquisition, the difference between these two important terms. They are two important inorganic corporate restructuring activities which companies undertake to acquire shares or stocks or voting power or control over the target company. But because to make sure that this is not done in an arbitrary manner, the code provides a set mechanism to be followed, to be complied. It provides various unique features which were not present under the previous code, such as it provides exit option for public shareholders to exit. It also provides and states it allows the raising of threshold for making an open offer from 15% to 25%, whether it is a direct open offer or indirect open offer. And also it gives a revised list of exemptions, and many more such unique features are there which were not present earlier. Therefore, it would be right and correct to conclude that Takeover Code 2011 focuses on the principles of corporate democracy, transparency, fairness, and it also ensures the interest of investors, which is the primary objective of the SEBI Act. Thank you.